Hi, I'm Pat DiDomenico, Editorial Director at the HRSpecialist.com and Business Management Daily. You know, lawsuits and legal complaints filed by employees have been exploding nationwide over the past decade. It's important for managers to do their part to prevent legal disputes by knowing the basics of employment law. How well do you know the law? Let's take this quick 5-question quiz to find out. Number 1. What are the most popular types of job discrimination complaints, in order, filed by employees? A. Age, race, and disability discrimination. B. Retaliation, race, and sex discrimination. And C. Sex, race, and retaliation. The answer? B. Retaliation, race, and sex. You may be surprised that retaliation is number 1, but all those federal laws that prohibit job discrimination or guarantee family leave also include anti-retaliation provisions. They make it illegal to punish workers who voice complaints or use job-protected FMLA leave. The lesson? Even if it makes you mad, never lash out at employees for exercising their legal rights. 2. Say an hourly employee works overtime hours that you, his manager, have never approved. Federal law says that you, A, can dock the employee's full pay for those unapproved work hours, B, can dock only half of his pay, or C, cannot dock the employee's pay at all. The answer? C. You cannot dock pay for unapproved hours. U.S. Department of Labor rules specifically say that time spent doing work not required by the employee, but still allowed, is generally still hours worked. That doesn't mean employees can work whatever hours they want and you have to pay them. But instead of docking their pay, you should discipline employees for those off-the-clock hours, say with suspensions or, if needed, termination. Question number 3. At what age are workers protected by the Federal Age Discrimination and Employment Act? Age 40, age 50, or age 55? The answer? A. 40 years old. The ADEA makes it illegal to treat someone, either an employee or an applicant, less favorably because of their age. That includes hiring, firing, pay, job assignments, training, benefits, or any other condition of employment. The law does not protect people under age 40, but a handful of states actually do that. So check your state law. Number 4. The law sets limits on the number of hours and types of tasks that you can assign young workers. So at what age under federal law can employees perform any job with no limits on hours? A. 17 years old, B. 18 years old, or C. 19 years old? The answer? B. 18 years old. That's because the Federal Fair Labor Standards Act sets both hour and task duties for 14 and 15-year-olds. Everyone who is age 16 and 17 is not limited in the hours, but can only be working certain non-hazardous jobs. Employees age 18 years old and older can work any job for unlimited number of hours. Note that some states do have their own child labor laws, so check your state law before hiring anyone under 18. Number 5. We finish with a true-false question. To be eligible for job-protected leave under the Family and Medical Leave Act, employees must specifically request FMLA leave to their managers. True or false? The answer? False. The FMLA guarantees certain employees up to 12 weeks of unpaid job-protected leave each year. But employees don't need to assert their FMLA rights saying something like, I need FMLA leave. In fact, they don't even need to mention FMLA at all. When employees give a reason for leave, it's the employer's responsibility to identify leave requests that qualify under the FMLA. That could include leave for pregnancy, for their own qualifying serious health condition, or for a parent or a child's serious condition. So when in doubt, contact your HR people, have them sort out the details. Thank you for joining me today for this quick employment law quiz. As you can see, it's important for managers to know at least the basics of employment law. I'm Pat DiDomenico, Editorial Director at the HRSpecialist.com and Business Management Daily.